Hi, I'm Alan Lowenthal, and this afternoon we're going to be discussing COVID-19 and the significant impact it's having on the ability of companies to satisfy their performance obligations under their agreements with their customers. Right now, companies and their lawyers are scrambling, looking at their agreements, trying to find contractual language that'll excuse their non-performance under their contracts. Reasons for their non-performance can be anything from a lockdown in your particular state, inability of employees to come to the office or to the factory to produce the manufactured goods or to perform the necessary services required under a contract. It can be many other reasons why companies are unable to perform at the present time. On screen is a template force majeure provision. A force majeure provision is really nothing more than a laundry list of events that the occurrence of which will operate to excuse a party who is otherwise required to perform from actually performing under the contract. It is only valid and will only protect a company for the duration of the underlying event. What is required for a force majeure provision to be deemed enforceable by a court? First, the event could not have been prevented by prudence, diligence, and care. In other words, it was not foreseeable at the time the contract was entered into. Second, the event can't be caused by the party charged with performance. Third, it must use reasonable efforts to limit the event's impact on their ability to perform. An important note to make is that as soon as your company determines that it is unable to perform as a result of the event of force majeure, it is required to promptly notify the other party as soon as possible of the event. If performance is able to be done, but the transaction is no longer profitable, that is not going to be sufficient to trigger the benefits of force majeure. If, for any reason, your contracts do not have a force majeure provision, or the one you have, for whatever reason, doesn't satisfy these requirements, you may be able to use the doctrines of impossibility and commercial impracticality. First, the doctrine of impossibility provides that a supervening, unanticipated event and its reasonably expected consequences will make the performance under the contract impossible. The determination of whether the doctrine of impossibility is going to apply is going to hinge on whether the supervening event and its foreseeable consequences was or wasn't reasonably foreseeable at the time the contract was entered into. It is not available to excuse performance if the party would merely suffer an economic loss or hardship. If for any reason the doctrine of impossibility isn't applicable, you may be able to rely on the doctrine of commercial impracticability. Under this doctrine, your obligation to perform is made commercially impractical solely as a result of a material event, the non-occurrence of which was a basic assumption the parties reasonably relied on when they entered into the agreement. First, the event must render performance unduly burdensome. It can only be, meaning that it can only be performed with unreasonable risk, substantial expense, and great difficulty. Second, the event's non-occurrence was assumed by the parties at the time of contracting. Again, it wasn't foreseeable when the parties contracted. Third, the affected party cannot be responsible for the event's occurrence. Fourth, the party seeking to use this as a defense didn't fail to take reasonable measures to overcome the event. Lastly, I'd just like to spend a moment talking about the value of including specific conditions of performance or non-performance in your contract. Specifically, the occurrence of an event in the future can trigger an obligation to perform or not perform. A typical example that we're all familiar with of a condition to perform is a standard real estate purchase contract. The obligation to close is typically contingent on a satisfactory inspection report and/or obtaining third-party financing. Again, a good example of a condition that has to be satisfied before the parties are required to move forward to closing. Depending upon the industry and the product and service that you offer your customers, consider conditions for everything from a foreign currency exchange rate ban if your company imports or exports overseas. You can condition performance in a contract on commodity availability, depending upon, again, the type of product that you manufacture. You can condition performance on specific supplier availability. Again, all of these can be inserted as provisions in a contract, conditioning your company's performance or non-performance on the existence of these facts. In conclusion, confer with experienced contract counsel to determine whether or not you're able to exercise a force majeure provision that may be in your contract, or if not, you're able to rely on any of these other legal defenses for non-performance. To the extent you have any questions or would like to discuss your particular contract in question, don't hesitate to contact me anytime at the phone number and/or email address shown at the end of this video. Goodbye and good luck.